Hello everyone, Kit here, back with another video. Today guys, I'm back with I think part 3 of the County Sheriff's Handbook. Once again, I'll leave a link to this down in the description box below. For email, you can email us at themongs@gmail.com, private consultation. Without further ado, let's pick up where we left off. Shall not infringe. Various, various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. The preamble to the Bill of Rights. Congress of the United States Congress of the United States begun and held at the city of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states having at the time of their adopting the Constitution expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the benefit ends of its institution. Resolved by the Senate and House of Representatives of the United States of America, in Congress assembled, two-thirds of both houses concurring, that the following articles be proposed to the legislators of the several states as amendments to the Constitution of the United States, of or any of which articles, when ratified by three-fourths of said legislators, to be valid to all intents and purposes as part of the said Constitution. Articles in addition to an amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislators of the several states pursuant to the fifth article of the original Constitution. Comment. Courts are to intercept the people's vested rights in the understanding of the common law. Unalienable rights are the ruler that limits all statutes and all court decisions. If they don't measure up, they are null and void. Amendment 1. Congress shall make no law representing an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble and to petition the government for redress of grievances. Comment. For government servants to designate areas called free speech zones are absurd and must be disobeyed. Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Comment. Militia Act of 1792, passed May 8, 1792, provided for the organization of the state militias. It conscripted every free able-bodied male citizen between the ages of 18 and 45 into a local militia company. New York State Constitution, Article 8, Section 1. The defense and protection of the state and the United States is an obligation of all persons within the state. Therefore, it is clear that it is the right of the people to own arms, and nothing is to infringe upon that. Licensing a right is an infringement. Is it infringement? Running a background check before selling a firearm is not. But background checks are infringements if one must wait for the result before being able to get his firearm. Amendment 3. No soldier shall, in a time of peace, be quarantined in any house without the consent of the owner, nor in a time of war, but in a manner to be prescribed by law. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures shall not be violated. No warrant shall issue but upon probable cause. supported by oath or affirmation, and particularly prescribing the place to be searched, and the persons or things to be seized. No warrants, including federal warrants, are to be served without going through the sheriff's office. Any warrant without a sworn affidavit and a judge's wet ink signature, not a stamp, is not an executable warrant. It is the sheriff's duty to make sure that all warrants, federal or state, served within their county passes constitutional scrutiny. IRS warrants rarely pass constitutional scrutiny. For example, the IRS has a Form 4490 called Proof of Claim for Internal Revenue Taxes, which is an affidavit form that must be filled out and sworn to, without which the warrant with the wet ink signature is not executable. Amendment Amendment 5. No person shall be held to answer for capital or otherwise infamous crime, unless on presentment or indictment of a grand jury, except in cases arising on public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compensatory processes for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Comment: solitary confinement, disentling, and refusal of medical needs are physiologically and physically destructive, and therefore cruel and unusual punishments. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage the others retained by the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The consent of the governed. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Declaration of Independence. We the people consent to government by exercising the following 7 unalienable rights. When we freely elect committeemen to whose the candidates will be on the ballot. When we cast out vote at the ballot box, when we exercise our right of recall, when we exercise our right as grand jurors to indict or not, when we exercise our right as pt3 jurors to convict or not, when we exercise our right of nullification, and when we exercise our right of denying courts not of record. By the aforesaid rights, we the people have total control and consent of government and exercising of our liberty. Any infringement upon any of those unalienable rights is an act of war against the people, against the Constitution, and against God. The people are entitled to the laws of nature's God. The people are entitled to the laws of nature's God. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth and separate and equal station to which the laws of nature and of nature God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes of which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving from their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Declaration of Independence. Informed jurors. Common law court is one that carries out the will of the tribunal, aka the jury, under the principles of the common law, and consists of a free, unattained, and fully informed jury, a magistrate who administers the will of the jury and not his own, a prosecutor who represents the people and not the government, and 4. A constitutional bailiff, aka sheriff's deputy. Jurists and bailiffs must be under the people's control and not political. It is the duty of the jury administrators to fully inform jurists of the following: 1. Jurists must act with a sense of honor. 2. Jurists must act with a sense of justice. 3. If jurists find the defendant guilty, they must consider mercy. 4. The people have a right to see the grand jury without a monitor. 5. Grand juries must consist of 25 people. 6. Petite trial juries must consist of 12 people. 7. Jurists must refuse to enforce unjust laws. 8. Jurists cannot be required to ignore their consistencies. 9. Jurists cannot be punished for their verdicts. 10. Jurists have the power of notification. 10. Jurists decide both facts and law. 12. Jurists must restore and/or compensate the injured party. 13. With the exception of dangerous people, jail should be the last resort. The convicted must be able to pay restitution. If the jurists are not concerned with the convicted escaping their punishment, their movements can be monitored electronically. There is no such thing as a hung jury. Jurists must remain in deliberation until they reach a verdict. 15. If jurors are absolutely deadlocked, they must acquit. 16. In order to convict, it must be an unanimous decision. 17. 17. If jurors are the king's bench and must do their best to exercise the will of the king, God of the court. Only the people can file a criminal complaint. There are only 4 ways a court can hear a criminal complaint. One or more of the people sign a sworn affidavit that they have been injured and seek a grand jury indictment. The sheriff or coroner can directly ask the grand jury for an indictment. A prosecutor on behalf of the government or the people can bring an accusation before the grand jury, and the grand jury can either indict or do nothing. The grand jury, by its own will, can investigate merely on suspicion that the law is being violated, or even because it wants assurance and it is not. And if it finds wrongdoing, it can present to the court and must go to trial. No one can second guess the grand jury unless the grand jury's actions violate another person's unalienable rights. Consent of authority. We read in the Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are governments instituted among men, deriving their powers from the consent of the governed. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under U.S. Codes 42 and 18 and liable for damages under U.S. Codes and common law. Consent to indict. The Fifth Amendment states no person shall be held to answer for capital or otherwise infamous crime, unless on presentment or indictment of a grand jury. Therefore, our servant government requires the people to get an indictment, grand jury. Judges' servants have no authority to make a ruling or a judgment on people, master, without the people's consent. In legal terms, when the judges of a court not of record to ask you, do you understand? He means that do you understand the authority of this court? If so, if you say yes, you must give him or her jurisdiction over you. Nevertheless, if the person standing before the judge is not informed of the court's intent, the judge would be subject to charges of fraud. Alright, I've ended off here. Once again, I'll leave a link to this down in the description box below. For emails at themonies@gmail.com for application. And I'll see you guys in the next video.